Evictions when you own a mobile home. Mobile homes are sometimes called trailers, manufactured homes, or factory-built homes. Sometimes, mobile homeowners rent the land they live on. If you're a mobile homeowner leasing the land you're living on, there are some special legal issues you should know. Most important, if you're being evicted, you still own the home. The landlord can't just take it, but it's your responsibility to remove it or sell it. Moving the mobile home can be a costly and complicated procedure. There are two documents you should have as a mobile home owner who leases the land they live on. One is a title to your home, and the other is a lease for the land. If you own a mobile home, instead of a deed for land, you should have a title. You'll want to have this in case you need to sell your home. If you don't have it, you can get it at the DMV. Take a photo of it and keep it safe. The other document you need is a lease. This is given by the owner of the lot. This lease should have a fixed term, at least a year. The lease will have some key information, like the amount of lot rent owed, when rent is due, a list of fees and services, a copy of your community's rules, and how long your lease is. Generally, a landlord cannot require a tenant to move a single-wide trailer off a piece of property for a year after it was placed there, unless good cause exists. And a landlord cannot require a tenant to move a double-wide home off a lot for 5 years after it's placed on that location, unless good cause exists. A landlord can evict you anytime good cause is shown, regardless of the lease. Good cause for eviction includes but is not limited to not paying rent, breaking other terms of the lease, intentionally damaging the property, or not preventing easily preventable damage to the property. End of a lease. Finally, at the end of a lease, a landlord can require you to move your mobile home off the lot. They must give you notice 3 months before the lease ends. The landlord must give written notice if you're being evicted. The notice should tell you the reason for the eviction, the specific facts, like the date, place, and witnesses. The notice should be given to you at least 3 months before the landlord terminates your lease. After 3 months, if you have not left, the landlord can file a lawsuit in court to remove you. If the violation is something dangerous or violent, you could be evicted faster. If the landlord wants you to move, you're going to have to. If you don't, you could lose the home itself. Eviction process. Once the landlord sues you in court, the case proceeds through the regular eviction process. Step 1. First, a landlord files a case in the court and serves you with several documents, including the petition for summary relief, wrongful occupation of factory-built home site. After this, the case will follow the regular process for an eviction in West Virginia. Please watch our private housing evictions video for more information. Mobile homeowners have a few special rights. First, after an eviction, the landlord is not allowed to dispose of or sell a tenant's mobile home for 30 days, and you have 60 days to go back and get your stuff, though the landlord can charge you for storing it. Also, West Virginia law prohibits the landlord from shutting off utilities, moving a resident's mobile home without their permission, or trying to force them out. You can apply for free legal help with eviction or issues with renting a lot for your mobile home by calling Legal Aid of West Virginia at 1-866-255-4370 or apply online at legalaidwv.org.